And hello, friends. Welcome to another episode of Chapters here on Armstrong Television. Chapters is the show that profiles authors, editors, and publishers in our community, which includes the states of West Virginia, Ohio, and Kentucky. I'm Eliot Parker, and it's great to have you with us. If you've been a regular viewer of the program, or maybe a recent viewer of the program, you know that our primary focus is profiling those authors, editors, and publishers that inhabit West Virginia and the border states of Ohio and Kentucky. Today, we're taking a little bit of a different approach on our program, and we're going to talk about the legal aspects of writing and some of the concerns that writers and published writers need to think about with regards to contracts, with regards to all the different kinds of legalese steps and legalese processes that take place when a publisher contacts an author and decides that they want to publish their work. And in that discussion today, we are pleased to have attorney Christina Smith with us here today. She has been a practicing attorney for 20 years. She began her legal career as a writ clerk for the West Virginia Supreme Court. Since leaving the West Virginia Supreme Court, she's worked as both a defense and a plaintiff's attorney. While working as a defense attorney, she participated in defending numerous mass litigation cases, including work in tobacco and pharmaceutical cases, as well as defending doctors and hospitals and medical malpractice cases. As a plaintiff's attorney, her work was concentrated in the areas of personal injury, wrongful death, deliberate intent workplace injuries, and insurance bad faith. She's currently working on the nationwide opioid litigation on behalf of counties and cities who have filed suit against the opioid manufacturers and distributors. She's admitted to the United States Supreme Court, plus the federal and state courts in West Virginia and Kentucky. Her appearance before the U.S. Supreme Court was sponsored by nationally renowned attorney Theodore Olson. She received her bachelor's degree from the University of Kentucky in 1991, where she graduated with honors, and she received her Juris Doctorate degree from West Virginia University College of Law in 1997. She's a member of the West Virginia Bar Association and the West Virginia Association for Justice. And we're so glad to have Christy Smith with us here today to talk about all the legal parts of writing that oftentimes we don't think about as writers. I wanted to ask you first, before we kind of get into some of the more nuanced or technical aspects of our discussion today about legal issues with writing. First off, what is a contract? When we hear that word, a publisher contacts a writer and says, we want to publish your work, we want to publish your short stories, we want to publish whatever, we're sending you a contract.
Yep.
So what is that contract?
A contract is a legally enforceable exchange of promises, essentially. A contract formation requires three essential elements: an offer, an acceptance, and consideration. The offer promises the offer something in exchange for the offeree's promise either to do something or to not to do something. And the acceptance, the offeree accepts that, and the consideration is the money and the book. So in a contract, it would be the publisher offering to purchase your book, the author offering the book, and then the consideration is the money and the book. And then it becomes a legally binding document that you are obligated to hold up your end of.
So when a writer gets a contract from a publisher, what are some things they need to be looking for? I mean, I know that every contract is different. I've had different contracts from different publishers myself, and several of our writers and publishers and editors that have been on the program have as well. But are there certain things that every book contract should have, or something that every writer should be looking for in that book contract to kind of let them know that you're getting a legitimate offer here?
You always want to remember that everything is negotiable before you sign the contract, and that after you sign the contract, it is not negotiable. So you want to make sure that you have looked at all of your rights, because when you look at a contract, you kind of want to think of what's the worst way that this can be interpreted for against me, because they have written it. So you have to look at it and make sure there's not vague language in there that limits when they're going to pay you, or how they're going to pay you, or how they calculate what you're going to be paid on. So you always have to, and what are you giving them? One of the first things you should look at is the description of the work. What are they actually contracting you to do? Is it just for this one book, or is it for a series of books? Have you signed on? Are they giving you an advance for 3 books? And is there a time frame of when you have to have those 3 books done? So do you think that you can make your obligations under that time frame? So you always have to look at what you're actually being contracted to do, because some people might not realize if it's just for 1 book, and they think that they've just got to write 1 book, but it might say 3 books in there. So you always have to look at what are your obligations, and what do I have to do, and what are their obligations to me, and what can I expect from them? So that's the first thing that you want to look at. Another thing you want to look at are the rights. Are you signing over just your media rights, or are you signing over your territories? Is it United States, just United States rights, or is it international rights? There's different or are you signing over your movie rights? So they might just be purchasing the rights to the media and the book, and not movie rights. And in that case, you can still take that idea, if the terms allow it, and you can use it to go and sell those movie rights yourself. So you always have to look at what you're actually giving them.
Yeah.
So what it is you're obligated to do. So that's and are they exclusive rights versus non-exclusive? Like with some agents, they don't represent. They only do publication rights and they don't do movie rights, and so they might have a non-exclusive that they're just doing the publication rights. So those are some of the catchphrases that you want to look for, and time frames, and subsidiary rights, which is the movie rights, radio, dramatic performances, and that kind of thing. So always look at what you're actually obligated to provide.
Very good. And I know that, one thing that all writers are always interested in too, as part of the contract, is the royalty structure. Can you talk a little bit about that, and what is some language that writers need to pay close attention to when they get to that section of their book contract with regards to royalties?
Yeah, I can give some advice, and I feel like I probably always have to say, as a lawyer, I have to disclaim that I am not your lawyer. This is for general information purposes, and nothing. We have not formed a legal contract. I have not given you any offer or acceptance. So, and take everything that I say, and when you get a contract, go obtain a lawyer. So I probably need to put that out there first. So the royalties, you have to look at how are they going to calculate it. Like most royalties are specified as a percentage of the cover or the suggested retail list price. So you can calculate what that amount is. But you got to be aware, because some people, from what I have read and heard about, slip in some kind of wishy-washy language in there. It says publishers' net receipts. Well, how are they calculating the net? If it's not, if you can know if you're getting 50. It's never going to be 50%, but like if you're getting 50% of a $10 book sale, then you get $5. If you're 50% of a publisher's net receipts, that's how much they, the book price minus whatever expenses they have. How are you? You don't know exactly what that's going to be. So beware of kind of amorphous general language that doesn't really tell you how they're calculating or where they're going to calculate that number from. And then you need to look at how often are they going to be paid. I mean, a lot of times it's like 2 times a year, I believe they send out checks, but that's something you need to know, especially if your career is just writing. You need to go, well, when can I expect the money? Show me the money. When are you going to show me the money?
Right.
And then you also want to look, you should have an ability to hire an accountant and audit your royalties. Nobody ever does it, but it is nice to have that language in there as a protection for yourself, so that you can go in and say, have they given me my fair royalty, especially if they have this amorphous publisher's net receipts language in it.
Yeah, and the net receipts you were talking about, their expenses that are kind of taken out of that, and that could be things like wholesaler, distributor costs.
Correct.
It could be bookstore expenses.
Yeah,
it could be
marketing,
all those things, right?
It could be anything, and if you don't know what that is, then you could end up with 50 cents for every book if there's no way for you to that. So that's just some language you need to look out for.
And kind of on the flip side of royalties, and I know you mentioned this a few minutes ago about advances.
Yes.
That some publishers will offer a author an advance. Oftentimes that comes if they're interested in a series of books, for example. They'll publish your first book and then give you an advance to write books 2, 3, and 4.
Correct.
So kind of what is an advance, first of all, and then what are some things, again, a writer needs to pay attention to when they get to that clause in their contract?
Yeah, an advance is kind of, an advance on your royalties. It's like we're going to kind of like them betting money that you're going to make this amount of royalties. So we're going to go ahead and give that to you. And then once your book has earned out that advance, then you'll start getting your royalties. So it's a way for them to, keep you writing, especially if it's a series that they want, so that you can feel some commitment or some security while you're writing the book. And but they also do expect you to earn it out, and they do expect you to write the book. So you have to be careful. You can't take an advance and then, be like, I didn't write the book, got writer's block, and then you'll have a certain length of time a clock that you will be on. Now, I'm sure some people like James Patterson's people get advances and can get an extension on that, but most normal, regular authors, you've got to, if you take that advance, you need to know you have obligations, and that's just not free money.
Yeah. And like you said, you can't get cold feet and decide, well, I've kind of lost motivation to write that book.
And I've spent the money. Sorry, that's going to get a quick way to get sued.
Yeah, absolutely. And a couple other terms I wanted to ask you about too that we see pop up in book contracts: copyright. What is that, and what are some things that authors need to consider with that?
Copyright. You pretty much. I'm not a copyright lawyer. I didn't really look at this too much, but a lot of people think you got to stamp it and send it in, and people still do that. But under the law today, usually once you write something, it's kind of automatically copyrighted. Like I said, I haven't looked at that much lately, but they will usually, the publishers will say upon publication they'll register the book for a copyright. So that's a step that they add in for you, you usually want to get that done within 90 days of the contract being executed, and
okay.
the book being completed.
Okay.
Sorry.
and oftentimes too, I think you see that if you read, the first index page or the second index page, it'll say,
yes,
book is copyrighted to author so and so. Names and faces are not meant to depict anybody real.
Right. There's that general, a pretty standard paragraph that everybody puts in there. So
yes. Okay. And another question I wanted to ask you is about termination. And I know that most book contracts I've looked at, and I know you've probably seen many more than me, have a termination provision. In other words, kind of, if I don't want to work with this publisher anymore, or if we get into the first book and it's just not working out, maybe I don't have an advance and I'm just on a standard royalty contract. Mm-hmm. What are some things that authors need to be looking for in terms of the termination provision and maybe the terms that are associated with that?
Yeah, and a lot of the termination provision stuff is more of with an agent. Publishers, they just, it'll be in the contract, you just won't sell them anymore. There are always going to be clauses in a contract that you can terminate it. Like say they buy 2 books they buy a series and the series doesn't perform. They'll usually have language in there that tells you if it doesn't do this, then we can do this. And then I haven't looked at a contract in a while, so I can't remember what rights you have to terminate that. But with an agent, you can terminate your relationship with an agent, and there's a lot of thing about they have to give you your best efforts. Like an agent is supposed to be working hard for you and securing a publishing deal, but say you sign with an agent and they're not the best, and your book just sits on their desk for a year and they're not doing anything with them. The contract should outline what best efforts are, and so then you can say, hey, give them notice, hey, you're not giving your best effort, so I'm putting you on notice. There usually should be like a notice clause in there, because an agent should typically, review your work, provide you editorial guidance, develop a strategy for publication, and be an advisor on the publication industry in addition to marketing your work. There's a lot of things that, and they should monitor your royalties. And so you need an accountability clause in there for your agent, and there'll be obviously one for you too, especially if you've received an advance. But that is when people sign on with agents, because there's so many people out there claiming to be agents these days, and first of all you need to research agents and make sure that they're credible before you sign with them, but also make sure that you haven't signed away like all of your you haven't given them your work, that it's a beneficial relationship. So you need to look at, like I said, when you're looking at a contract, you always have to look at what do I have to do and what do they have to do, and make sure that that you have a way to hold them accountable for what they have to do.
Excellent. I think that's excellent advice. We'll come back to contracts in just a second, but I know you and I talking, over email and before the show. I know one thing that really concerns you that you study a lot is writing about the law realistically, and writers who have courtroom scenes, have scenes with police, have scenes with attorneys, and doing it right and doing it well. So I just wanted to give you two examples that we've talked about, and have you kind of explain what you mean by the differences there. So. How to Get Away with Murder, which is
I love it,
which
but
is
crazy pants, and I have to suspend all belief. They live in a different legal universe than I do.
Yes, absolutely. So you got Viola Davis. It's a great show.
Fabulous.
And then the courtroom scenes that we see, let's say in Law and Order or Law and Order Special Victims Unit. So what's wrong with how they do it on How to Get Away with Murder, and what's kind of right with what they're doing with Law and Order?
On How to Get Away with Murder, they there's always surprise witnesses, and there's always surprise evidence, and there's always long emotional outbursts by Viola Davis, which I love watching on TV, but you do that in a courtroom and you're going to get sanctioned. You'll get about one sentence of that out, and they're like, with their gavel, and you'll be yanked back to the chambers. So those are all things, I mean, people don't realize how tedious and slow and boring trials are. I would encourage anybody that's actually going to write about any kind of courtroom legal drama, actually go observe just a day in the court, because most trials are open to the public. Just go in and see what the pace is, because it's slow. The whole judicial process is slow. Things don't, I know for dramatic purposes, they all have to take place in an hour sometimes on TV, but Law and Order, I think, gives a little bit better of, they kind of slow the pacing down. They don't make the show all seem like it happened in 2 days. You know, they do kind of hint to passages of time in between that. Whereas How to Get Away with Murder and Suits, and I love Suits too, but Suits is like, and we're having trial tomorrow. I'm like, no, you're not. Yeah. That's not how any of this works. And so I would go sit in the courtroom and get the feel of what happens in a courtroom and how the judge has complete control. I mean, they know in the TV shows, they never really show the judge. The judge is always kind of like at the last name, but the judges rule everything, and the attorneys know you sit and you speak when you're given the opportunity, but you don't have loud speeches and emotional outbursts. You certainly don't bring surprise evidence and surprise witnesses into the courtroom. And that's another thing I don't think people realize, unless they've been involved in the cases. Lawsuits are slow. They take years. Everybody knows before they get in a courtroom not only exactly who the witnesses are, but usually exactly what order the witnesses are being called. They know what pieces of evidence are being used with that witness. It is a slow process, which doesn't make for exciting writing, which is why a lot of people, enjoy these legal shows. I love these legal shows, even though I want to throw my shoe at the TV sometimes, because it's just not right at all. But I think even if you do want to bend reality a little bit to make it more fun and creative, at least kind of go watch and see that there's a bailiff and a court reporter and a clerk and what everybody does and how the jury is, and just kind of get it. Even if you aren't going to write about the law, I think it's still a good process for everybody to go to. My parents have both been on jury duty, and they're both like, wow, that is not what I expected. So I think just actually getting in and watching it, it'll be boring and you'll want to leave after an hour.
Right.
But you won't be binge watching a real trial.
Right, absolutely, absolutely. I can remember that there was, when the Casey Anthony trial a few years ago, I can remember that was on one of the court TV, maybe it was court TV, and I was amazed at how, they had it on, of course they televised everything, and how you'd watch, like you said, 8 hours worth of trial, and maybe there was 10 or 15 minutes worth of interesting things,
yes,
and it
maybe.
oftentimes dealt with, the state's attorney and then her attorney disagreeing over something, and the judge having to settle it. But yeah, there was a lot of downtime and a lot of procedural and a lot of recess, and, trial.
And most cases don't go to trial.
Right.
I mean, there's a motion practice, so you have a lot of cases get decided on motions, but most of them get decided in mediation or settlement negotiations that continue after mediation. They just don't, there's just not a whole lot of most people weigh the pros and both sides have to weigh the pros and cons and go, and figure out whether it's worth going to trial, because it might not be.
Yep.
A lot of times it's not. A lot of times both people have something at stake and something they can lose, and so they find a way to negotiate it in the middle, which is kind of what most of discovery is about, is how can I have advantages in the mediation so that I can convince the mediator, this is what I'm going to say, and I think this is what the jury's going to believe, and then mediations can go on for like a day or two, but they are also slow and tedious. But there are different things other than a trial. If somebody wants to write about a legal drama, there's different, like, that they appeals, an appellate argument. Those are always, those can be interesting. If you want to speechify, then an appellate argument is the place to have the big speechy moment. I had to in How to Get Away with Murder last season. They had this big class action was first. It just cracked me up because they said they needed 75 plaintiffs for a class action, which is not true. You can have as little as 4 people for a class action. So they spent episodes going, we need to get our 75th plaintiff to go, or we're never going to get this class action in. And I'm like, that's not how any of this works. I do class action litigation. And then all of a sudden, right before trial, the state Supreme Court decided, no, we're going to take the case before you even have a trial. And it wasn't on any issue. And it was like, that's not how that happens either. So there are different ways you can go, but just try to keep it in reality. you know?
Makes for good television,
it
but
makes
not
for
always
great television,
but not always true to the I understand.
Correct.
And I know that as an attorney, you've had sort of an interesting career, done a lot of different things, but one of the things that you did not too long ago was sort of take a year off from legal work,
yes.
and that led you to writing your first novel.
Yes.
So that is coming out, I believe, you're hoping in October of 2018?
October. I'm hoping for October 18th is what I'm shooting
October
for.
18th?
I got to give myself a deadline because otherwise I'll let work get in the way and I won't finish it. But I'm finishing up actually the last round of edits and then just have to go to the formatter and then it's good to go.
So tell us about your book.
My book is kind of a dark thriller with some comedic aspects to it. It is about a young female comedian who has a really bad day and ends up killing a man in the park and then kind of becoming a vigilante. And then someone in her life finds out about it and blackmails her to kill someone, and she has to find a way to get herself out of, because the killing the man in the park was an accident, and so she has to find a way to get herself out of all the trouble that she's gotten herself into on her little vigilante spree. And it is set in the legal world. So, and I tried to make it as realistic she's a paralegal, and so I tried to make it as realistic legally and yet also interesting at the same time.
Sounds great. So, was it a challenge to write that book, even though you spent so much time in law and dealing with law and being an attorney?
Yeah, well, anytime you stare at a blank page every morning, it is a challenge to write a book. But I kind of saw this book. It kind of came to me, and that's why I knew life is too short. I have to take a break from the law and actually write this, or I will always regret it. And so it was fun. It was more fun to me because this woman had been talking in my head, and you know how when you write, your characters talk to you and they tell you. And I had one idea of what the story was how it was gonna go, and she's like, no. I'm not doing that. And then, and so every day I just kind of got to get up and play with these characters and not have to be a lawyer and but write about the legal field in a fun way and create these characters. And so I'm glad I took the break and did it, and I'm glad to be back to the law too. I will always appreciate the law, and I always like helping people and the challenge of research and writing, because you're telling a story. I mean, I am a brief writer. I do a lot of legal research and writing, and so I have to take the facts of the case and then the legal arguments and then craft a story that will convince the judge to first, in the motion practice, not throw our case out,
Right.
And then, create a story, help create the story for trial, should we go to trial, or to help with the mediator. So it's kind of the same thing, but this is obviously more fun.
Excellent. Well, Christine, our final moments with you, and I know you mentioned this, and we should reiterate this, that this is for general informational purposes. What we've been talking about today, nothing should.
No statements made
Right.
during this talk should be taken as legal advice,
Yes.
or for any individual case or situation, and is not intended to create an attorney-client relationship. But when you get a contract, please go see an attorney. Please do not sign anything that it costs so or ask someone, and make sure you look at all the terms and know your obligations, know their obligations to you, and always read it very, very carefully, because there will always be little squirmy language in there that can come back to bite you in the ass.
Yeah, absolutely. Absolutely.
Sorry, should I have done that?
That's okay. Christy Smith has been our guest here today on Chapters. We've been talking to her about contracts and language that writers need to consider when getting a book contract or reviewing a book contract. We've also been talking about how to write about law and courtroom scenes realistically in your novels and in your fiction and in your stories. And Christy, it's been a pleasure having you on the program. Thank you so much.
The name of the book is Killed It, by the way.
Yes, Killed It,
and
yes.
it will be actually written under the name Lulu Smith, which is my family nickname.
Perfect. So if folks want to reach out to you to get a copy of that, where will they be able to get a copy of the book, and how can they get in contact with you?
It'll be on Amazon, and I have a website, lulusmithauthor.com.
Okay.
And so they can read, there's an email on that, so they can, and it has a cover of the book, a summary of the book, a description of the book, and so they can go to my website.
Great, fantastic. Christy, thanks so much for being
you.
on Chapters. Great to have you with
thank
us.
You so
Thank
much.
you so much. We also want to take a moment to thank the staff and management of Empire Books and News for providing our on-site support and assistance today. If you haven't been down to Empire Books recently, we encourage you to come down and check out the all-new revamped store. I think you'll really be pleased with the changes and the features that have been made here right at Pullman Square at Empire Books and News, and we appreciate their support and sponsorship each and every episode of Chapters. We also want to remind you that we've made it possible for you to stay in touch with the program here on Chapters through a variety of social media platforms. One of those is our email address. That address is right here at the bottom of the screen. We do ask that you please include your name and town or community in which you're writing from so that correspondence can be kept track of. We also want to remind you that we have a YouTube and a Facebook page, and the YouTube page is also listed right here through the Armstrong One Wire page on YouTube. From there, just click the Chapters tab, and we've got all of our author, editor, and publisher interviews archived for you there as well. And our Facebook page address is also here at the bottom of the screen. There we have more recent interviews archived for you there as well, and you can share those to your page, comment, and interact with viewers of the program through Facebook. So if you like Facebook, YouTube, email, we've made all of those ways available to you for you to stay in touch with the program. We appreciate all the comments and feedback that we do receive from those platforms. And that will do it for us this time on Chapters, but please come again next time, and in the meantime, stay tuned to this station for news and views that impact you and your community.